The mechanism for international criminal tribunals is now in session. Lodgeon to mechanism for Lex Tribunal Penal International at UET. Please be seated.
Good afternoon to everyone in and around the courtroom. Will the registrar please call the case?
Thank you and good afternoon, Your Honors. This is case MICT 1596 PT, the prosecutor versus Jovica Stanišić and Franco Simatović.
Good afternoon, Mr. President and Your Honors. For the prosecution, it's Sarah Malikian, Grace Harbor, Adam Weber, Douglas Stringer, case manager Tomalo Gel, and our legal intern Charlotte Verkrai.
Thank you. For the defense, for Mr. Stanišić.
Good afternoon, Your Honours. Myself, Ian Edwards, can I introduce him as our new co-counsel? He's the man with the grey beard. And case manager Danko Kostovic, Katrina Murdoch and Joseph Holmes, and Ruby Axelson. And our interns, Elisa Sherio, Senan Downs, and Dorian Robinson. Good afternoon.
Thank you. For Mr. Simatović.
Dobar dan časni sude, dobar dan svima u sudnici i oko sudnice. Za odbranu Simatović danas su prisutni Mihajlo Bakrač, Vladimir Petrović i Melani Vraneš. Hvala.
Thank you. On the 21st of February, the president of the mechanism assigned Judge Joseph Masanche to replace Judge Solomon Bosa as a member of this bench. This is the first time that we are sitting with the newly reconstituted bench, and I therefore welcome Judge Masanche. Today's pre-trial conference is called in accordance with Rule 81 of the Rules, which requires a pre-trial conference to be convened prior to the commencement of the trial. In the course of the pre-trial conference, having heard the prosecution, the trial chamber would determine the number of witnesses the prosecution may call and the time available to the prosecution for presenting evidence. The trial chamber may also call upon the prosecution to shorten the estimated length of the examination in chief of some witnesses. In addition, the trial chamber, after having heard from the prosecution, may invite the prosecution to reduce the number of counts charged in the indictment and may fix a number of crime sites or incidents in respect of which evidence may be presented by the prosecution. Counsel have informed us that the accused, both of whom are currently on provisional release, have given their consent for the pretrial conference to be conducted without either of them being present. I remind the parties that the operative indictment for this trial remains the third amended indictment of the 10th of July 2008 from the original ICTY trial. As per the ICTY Appeal Chamber's judgment of the 9th of December 2015, the accused shall be retried on all counts of the indictment. In this regard, I recall that on the 18th of April 2016 and the 2nd of February 2017, the trial chamber dismissed motions by the accused that the res judicata and non bis in idem principles apply so as to exclude from the scope of the retrial certain matters from the original trial. Against this background, at today's pretrial conference, the trial chamber will not invite the prosecution to reduce the indictment. I turn next to the number of witnesses that the prosecution may call and the time available for the prosecution to present its evidence. On the 2nd of February, the trial chamber issued a decision limiting the prosecution's evidence primarily to that presented during the original trial and allowing the prosecution to present new evidence only in certain limited circumstances. Following this decision, on the 9th of March, the prosecution filed a revised pretrial brief and witness and exhibit lists. In view of the prosecution's revised witness list and the subsequent withdrawal of RFJ 175 from it, there are currently 143 potential prosecution witnesses. The prosecution intends to call one viva voce witness, 86 witnesses pursuant to Rule 111, and 7 expert witnesses. In addition, the prosecution intends to present the evidence of 49 witnesses pursuant to Rules 110 and 112. The prosecution has estimated that it will need approximately 107 hours to conduct the direct examination of its witnesses. Given the withdrawal of RFJ 175, the trial chamber has been informed that the estimate is now 104 hours. With respect to the categories of witnesses, I would like the prosecution to confirm that the number of Rule 110 and Rule 112 witnesses upon whom it proposes to rely.
Your Honor, just a slight modification, perhaps, of that number. And for the record, I'm going to refer first to witness RFJ 029, who we had indicated was a witness being tendered under Rule 110. In fact, this is a Rule 111 witness who we propose to bring into the courtroom. So that's one modification or correction, I should say, because there was an inconsistency in our witness list and his status there versus what was actually contained in the motion. And then secondly, witness RFJ 106 is not a Rule 110 witness, rather is a Rule 111 witness. So RFJ 106 and RFJ 029 are both Rule 111 witnesses, not Rule 110 witnesses. And I believe that should bring the number of Rule 110 witnesses to 20. And the Rule 111 witnesses now are at 86. We've, for the record, dropped a witness. As you've noted, Your Honor, we dropped a witness just in the last few weeks who had been down as a Rule 111 witness. Sorry, we're at 87 witnesses for Rule 111. 87 Rule 111 witnesses and 20 Rule 110 witnesses.
Thank you, Mr. Stringer. The trial chamber further notes that the prosecution has already filed a number of motions for the admission of witnesses' evidence pursuant to Rules 110, 111, and 112. Some of these motions concern new evidence which was not presented during the original trial. And in light of the decision of the 2nd of February, the trial chamber will decide in due course whether the prosecution is allowed to present this evidence. A decision is also pending on the prosecution's submission in relation to the chamber's limitation on new evidence, which was filed on the 28th of April. It is expected that the decision will provide clarity to the prosecution in seeking the admission of evidence and facilitate the conduct of the proceedings as we move forward into the trial phase. The trial chamber is thus aware that this pretrial conference takes place against the backdrop of a number of outstanding matters. Nonetheless, I believe that we can already proceed with discussing the estimated length of the examination in chief for some witnesses, the number of witnesses the prosecution may call, and the time available to the prosecution for presenting evidence. Before I hear from the parties, I recall that in considering the most appropriate mode of presenting evidence in order to ensure a fair and expeditious trial, the trial chamber does not only take into account the time needed for examination in chief. The trial chamber must also consider, for example, the time needed for cross-examination and questions from the bench, as well as the time needed for the trial chamber to read and evaluate evidence outside of the courtroom. I also recall that, having considered expert evidence on Stanisić's health condition on the 13th of April of this year, the trial chamber set a trial schedule limited to 3 consecutive days a week, each day composed of 2 sessions of 90 minutes with a 2-hour break. The reduced court time weighs in favor of evidence being admitted in written form to the extent that it does not prejudice the accused. Relevant to this is also the question of whether the evidence of some witnesses could be retendered from the original trial. I recall that at the last status conference on the 7th of April, the parties informed the trial chamber that they have made no progress towards reaching an agreement in relation to witnesses whose evidence could be retendered. While I understand the defense's cautious position in this regard, there must be a way for the parties to agree for some of the less contentious evidence to be retendered from the original trial. I emphasize that the trial chamber will expect the parties to reach such an agreement following the adjudication of the prosecution's motion of the 28th of April. I would now like to hear from the parties, first the prosecution, and then in turn counsel for the 2 accused.
Thank you, Your Honor. As you've indicated already, the prosecution in its submissions has indicated that we require 104 hours or so. It's about 104, I think possibly 104.5 hours of court time for prosecution case in chief. We understand the Chamber's decisions, both the February 2nd decision and then the subsequent decision in which it clarified somewhat or expounded somewhat on its February decision in denying the motions for certification, that indeed the prosecution witnesses, not all of the prosecution witnesses that we wish to bring, will be permitted to testify under the conditions set out by the Chamber in its decisions. We have largely adhered to our witness list. We've cut a number, as you know, but we find ourselves in the difficult situation, as has been alluded to by Your Honor a few moments ago, about where we stand in relation to a number of the undecided, a number of the pending submissions of the prosecution. Because before we can really know what our case is, and I'm going to repeat what the defense has said a lot in recent months about not knowing the prosecution case. The fact is the prosecution doesn't know at present what its case is going to be We know the case we'd like to present. That's always been clear to us. But we don't know the case that the prosecution will be allowed to present once we have more information from the chamber, and we're grateful that the chamber's indicated that the guidance will be forthcoming as it issues its rulings both on the pending Rule 111 motions and on our more recent April 28th submission. But at present, we don't have ruling on any of the Rule 111 motions or on our pending Rule 110 and Rule 112 motions or on adjudicated facts. And once we have a feel, if I can put it that way, once we start to get guidance and we start to understand how the chamber intends to apply the decision of 2nd of February, then it's going to put us in a better position, obviously, to know what our case is going to be, and therefore how best to make the adjustments that are going to be required in order to best put the case into evidence that the chamber is going to allow us to put. So we recognize that the numbers that we've proposed now in terms of the witnesses and the number of hours that we're proposing, 104, is something that's going to be affected by the chamber's rulings. Now, having said that, Your Honor, I would ask the chamber to recognize that if in fact witnesses fall away, witnesses who we would like to present are not permitted to testify because their evidence is viewed as new and not falling within the criteria, then we are possibly going to be asking to try to touch on some of that lost evidence among the witnesses who are being allowed to testify. And so it may be that a witness who is testifying, we will be asking for more time to lead a bit more evidence in an attempt to recover from the lost evidence of another witness not having had to come. But these are issues that obviously will be dealt with in the course of the trial on a case-by-case basis. So I only say that in order to indicate to the chamber that while we're at 104, and it may indeed be that that number goes down, it won't necessarily, in our view, go down in a way that corresponds directly to witnesses who are ultimately excluded from testifying. I don't know whether I've addressed all of the points that Your Honors have in mind. If you have any questions, but that's how we see things now. We are preparing for a trial that we expect will possibly begin. Again, we know that a number of issues, including health issues and provisional release issues, are pending that could affect the beginning date, the start date of the trial. But we are looking forward to beginning the trial, Your Honors, on or about mid-June with opening statements. I would remind the chamber, as Your Honor, Judge Hall, you certainly know from having sat in earlier trials here, we in the victim witness section, it's really 4 weeks advance time is what's needed to bring the witnesses here, do the necessary logistics in an orderly way. And so once we've got guidance and rulings now on the Rule 111 motions that are pending, we will diligently begin to undertake to start bringing the witnesses here in accordance with your decisions. And we're looking forward to starting this trial and making a lot of progress in the weeks that follow up to the summer recess in late July. If Your Honors have any additional questions, I'd be happy to respond.
Thank you, Mr. Stringer. Mr. Jordache, any reaction?
Two points, if I may, just very brief. The first point is that I'm not sure I follow the prosecution's logic. If the decision is, the 2nd of February decision is applied as we, the defense, see it, i.e. limiting the evidence to that primarily tendered in the first case, then I do not understand how the prosecution then intend to adduce that evidence which is lost, as they would see it, through the old witnesses. The 2nd of February decision relates not to witnesses but to evidence. The evidence is limited to that primarily tendered in the first case, which presumably means that if they call old witnesses, they cannot adduce that new evidence through the old witnesses. So I'm not sure I follow the prosecution's logic in that regard. That's my first point. And the second point is in relation to cross-examination and retendering. If the evidence is limited, as we suggest it should be according to Your Honour's decision, then first of all, we intend to do everything we can to allow non-contentious evidence to be retendered, and we will work with the prosecution to make sure we do everything we can to make that happen. And Your Honours will be aware that since the very beginning of this retrial in December 2015, I've made it very clear on the record that that is a device which I think should be and can be used in this trial in this retrial to shorten things. In relation to more contentious witnesses, if we are limited to those that were called in the last case, then again we should be able to abbreviate things. We are to an extent or to a large extent content with the cross-examination we did in that previous trial. Now of course we would like to, depending upon the prosecution's proofing, depending upon certain issues which might need some clarification, we'll want to cross-examine on those points, but we should be able to shorten any cross-examination of those witnesses quite significantly. So with luck and with effort on all sides, we ought to be able to really make some progress in expediting these proceedings. Thank you.
Thank you. I'm going to invite Mr. Stringer to see if he could be of greater assistance to your first question, but before I call him, let me hear from Mr. Baccarat.
Da, časni sud, evo da budemo ekspeditivni, pozicija odbrane Simatović je gotovo identična, da ne kažem slična ili gotovo identična poziciji odbrane Stanišić. Dakle, i mi pokazujemo izvesnu dozu zabrinutosti u pogledu ovakvog stava tužilaštva, jer mi tumačimo vašu odluku od 2. februara upravo onako kako je uvaženi kolega Đordaš i rekao. Dakle, po meni stvar je jednostavna. U novom suđenju ćemo izvesti one dokaze koji su bili u primarnom suđenju. Tako da ja ne vidim logiku i bojazan tužilaštva i nameru da neke nove dokaze koje su propustili da uvedu u prethodnom suđenju, uvedu tako reći na mala vrata kroz neke svedoke ili neke nove dokaze. Dakle, to je što se toga tiče. Što se tiče drugog pitanja koje je uvaženi kolega Đordaš rekao, i odbrana Simatović je spremna da sarađuje sa tužilaštvom u pogledu nekih nespornih činjenica, ali mislim da je najcelishodnije da po tim pitanjima idemo korak po korak. Dakle, onako kako se ti svedoci pojavljuju, i ja se nadam da iz ove perspektive možda nemamo jasnu sliku, ali da ćemo u toku trajanja postupka sigurno doći do nekih rezultata u pogledu ekspeditivnosti, u pogledu izbegavanja nepotrebnog gubljenja vremena, ponavljanja nekih stvari koje nisu za ponavljanje. Sve ostalo smo u našim odgovorima na podneske tužilaštva dali i mi ostajemo kod toga, čekamo vašu odluku. To je sve što sam ja imao da dodam. Hvala, časni sude.
Thank you. Mr. Stringer, can you assist in further clarifying the, I'm searching for the right word, ambiguity? I wouldn't say confusion, it doesn't rise to that level, but the concerns that defense counsel have raised?
Well, yes, Your Honor. The concerns are very much the prosecution concerns as well. And Your Honors know well the prosecution position regarding the February 2nd decision, and I'm not going to belabor that. Our position is set out in the various submissions that we've made. But the fact of the matter is that in the first trial, it could well turn out that witnesses were sitting in that box giving evidence, and they weren't asked things because other witnesses had come, or that evidence was not in dispute, or the prosecution felt that any given fact had already been sufficiently established by other evidence, or by adjudicated facts, or by any documentary evidence that were already presented or available. Now, we're going to have a situation, and it's for sure, Your Honor, that we're going to have witnesses sitting here who are going to know more than what they said in the first trial. And maybe this is something that's going to be clarified by Your Honors when it issues its decision on our April 28th decision. But I think what this trial is going to boil down to is whether the chamber wants to hear relevant probative evidence from witnesses who are sitting in this box, even if those words were not uttered by that witness during the first trial. And that's a very basic, fundamental question that we're all going to be faced with in the very early stages. And now, if the fact is that the chamber does not want to hear witnesses utter new things about which they have knowledge because it wasn't said by them in the first trial, then frankly, we don't see much of a point in having witnesses come and give evidence. At the very least, we then have a situation where we've established a baseline in which the prosecution case is going to be X, and it can never rise above that level because we're never going to be permitted to lead additional evidence or new evidence, relevant, probative evidence, but nonetheless new. We'll be stuck with a baseline which exists, which is the level of evidence presented at the first trial. And then we will spend the rest of the trial pulling down the level of evidence, possibly, during the course of defense cross-examination of those witnesses. Because I don't think the chamber is going to require the defense to conduct the same examination, cross-examination that they conducted the first time, or to ask questions that they didn't ask of this witness when the witness was sitting there in the first time. And so we're looking at a situation, and we've raised it in our submission on the 28th of April, a fundamental asymmetry. There's an imbalance in which the prosecution is not going to be able to lead new evidence or adduce additional facts from a witness in the box, while at the same time the defense is going to, I presume, be allowed to conduct a full and free-ranging cross-examination of that witness, which they should be allowed to do. We're not saying they shouldn't, but we've got a fundamental asymmetry that we're risking here. And so when we get into discussions like we're having now as to whether the prosecution can attempt to recover some of the lost evidence of witnesses who've been excluded under the terms of the Chamber's February 2nd decision, if we're now going to be even precluded from trying to recover some of that by leading potentially relevant evidence of a witness who's here before the Chamber, then I think that we've arrived at a situation that requires us to all consider why we're having a trial at all with witnesses. If the witnesses aren't going to be allowed to provide the chamber with all of the relevant probative evidence that they've got, then it raises a question of why aren't we just submitting the whole first trial in the form of transcripts? And that way, at least, there will be a balance. We won't be able to ask new things, but neither will they. It just raises the question of why are we engaging in this? And I hate to sound so dire, and it may be, Your Honors, that in the course of the case and once we get going and the chamber starts to apply its ruling in a way, all of this will sort of settle out. That's our hope. But I can only respond to the comments made by my learned friend, Mr. Jordash, by expressing our own concern that we've arrived at a situation in which the prosecution's going to be hamstrung limited strictly to the record of the first trial, while the defense won't necessarily be limited. And that's really the crux of the concerns that we've expressed in our 28th of April decision. I wish I could provide more clarity or assurance to Your Honor, but we do view it as our role and our duty to try to put on our best case. And we are struggling, if I can say that, to accommodate that duty, while at the same time trying to follow the terms of the Chamber's decisions. And we acknowledge and respect the Chamber's concern for the expeditiousness of the trial, given the health concerns and all the rest. But we're struggling here to find a balance between that fair trial, that expeditious trial, and one that doesn't, in our view, disproportionately impact the prosecution's ability to put on its case. So I guess my final observation would be that perhaps we have to wait until we get to that moment where there's a witness here who might know something more, who could maybe look at a document and comment on it, a document that wasn't available before, a document that they didn't look at before. And the Chamber then can have that information and can see in tangible form how relevant, probative that is, and whether on balance the fairness of the trial would be undermined by allowing that witness to comment on that, even if it in fact is new. And if that takes a little more time, then I suppose the Chamber will ultimately be the ones to decide whether we're going to take that extra time.
Thank you, Mr. Stringer. I thank counsel on both sides for their observations, which would all be taken into account in due course. I now move on to the next item, which is agreed facts. At the last status conference of the 7th of April, I took note that the parties had not yet agreed on matters of fact pursuant to Rule 70N, and that there was considerable reluctance to proceed with this matter in the absence of clarification from the prosecution as to what the defense claims as new evidence and allegations. I also take note of Stanisić's subsequent 5th of May submission, in which he accepted 849 of the 1,410 adjudicated facts proposed by the prosecution. I would now ask the parties if there has been any progress with regard to these two issues since the last status conference. Prosecution?
Mr. President, in respect to the adjudicated facts, the defense have more recently filed a supplemental submission in relation to that, and we are just now in the process of filing a response or a follow-up. And so I expect that the issue of adjudicated facts will be fully joined for your honors in the very near future. On agreed facts, your honors, and maybe if I could just sort of make it a bit more globally and talk about the agreement as to witnesses as well, because this is something I didn't speak about earlier. Agreed, we've been open since the very beginning to agreement on many things from the first trial. We don't have agreement as to proof of death, which we did have in the first trial, but we have yet to have agreement as to the documentation for the very basic issue of proof of death of victims. Our November 2016 offer to the defense for agreement as to 45 witnesses, I believe it is still on the table. The defense have yet to take us up on any of those, and based on Your Honor's comments, I'm sure we'll be following up on that with the defense here very quickly after we've received the Chamber's guidance in its subsequent decisions. But on agreed facts, I don't know, Your Honor, that to be honest, whether we've had any subsequent movement. Well, I can tell you there hasn't been any subsequent agreement. All of that is still on the table, and we would welcome the opportunity to revisit all of that with the defense if they're amenable, based upon the more recent decisions of the Chamber on the scope of the case.
Thank you. Mr. Jordash?
Nothing to add except when there's clarity concerning the 2nd of February decision, then again our position remains the same, that we will engage extremely constructively with this, and we will be willing to make, I think, not insignificant agreements of fact, as long as we understand the scope of the prosecution case, and as long as we understand where we are in terms of the prosecution's indictment and so on. So we are here and willing, and will engage very, very soon.
Thank you. Mr. Bakrash?
Časni sude, ja ću u najkraćem reći da odbrana Simatović na istoj poziciji kao i odbrana Stanišić i da u ovom trenutku zaista nismo u situaciji da se sporazumemo, ali smo također naravno voljni da u tom pravcu, kada budu donete odluke i razjašnjenja, preduzmemo korake. Hvala.
Excuse me, Mr. President, could I just make one observation in terms of the statistics? We could follow up with Your Honor's legal officers, but we have that there was only 593 facts that were agreed to, not 849. But in any event, we can follow up on that with your officers directly.
Thank you. I would now move to discuss the commencement of the trial. As you are aware, the trial chamber has received a request from Mr. Stanišić for an extension of his provisional release for the duration of the prosecution's case. The trial chamber is examining the arguments of the parties and will issue a decision in the coming days. In the meantime, Mr. Simatović has indicated that he will not seek an extension of his provisional release. Once the issue of Mr. Stanisić's request is resolved, the trial chamber will be in a position to set the date for the commencement of the trial. It is expected that the trial will begin soon after today's pre-trial conference, bearing in mind the time needed to allow for any accused to return from provisional release. And subject to this, the trial chamber envisages the trial to commence on the 13th of June with the opening statement by the prosecution. I would now invite parties to address the bench as to any matters that they would wish to raise in this regard. I note that the bench has been informed that counsel for the accused do not intend to make opening statements at the beginning of the trial. I'm also interested in hearing whether they maintain their position in this regard. Mr. Stringer, do you have anything to say on this point?
I'm sorry, in terms of opening statements? Or
Well, what is now our target date of the 13th of June? Sorry.
we'll be ready.
Yes.
We'll be ready. We're absolutely ready. The only sort of contingency is if we have enough advance notice based on Your Honor's rulings for us to make the necessary arrangements for the witnesses and any adjustments, obviously, for witnesses we would like to call who ultimately will not be testifying because their evidence is new. But we're going to be ready, certainly, for opening statements, and we're going to do our best to have the witnesses here in accordance with your decisions.
Thank you.
As Your Honours will appreciate, we filed yesterday an application for greater particularisation of the prosecution case. And we do say that the situation is serious. Nonetheless, if the 13th of June is to be the beginning of the trial, and if the 13th of June witnesses to be called are pursuant to the 2nd of February decision, i.e. that they are old witnesses, then looking at the old witnesses in the list of the prosecution's first 10, we are ready to cross-examine or deal with those witnesses.
And do you maintain your earlier indication of not wishing to make opening statements at the...
Yes,
Yeah.
no opening statements. Thank you.
Thank you. Mr. Bakrash?
Da, časni sude. Ono što se tiče naše odbrane, mi ćemo biti spremni za 13. juni, ukoliko, naravno pod uslovima koje smo i ranije isticali da se radi o svedocima koji su već svedočili ovde. Što se tiče uvodne reči, to ćemo ostaviti za početak izvođenja slučaja odbrane, s tim što želim veću da napomenem da postoji mogućnost, najverovatnije, da se optuženi Simatović u smislu člana 101 obrati svojom izjavom pretresnom veću nakon podnošenja uvodne reči tužilaštva. Vrlo kratko, uz naravno vaše dopuštenje, časni sude.
Thank you. I move now to the issues of witness protection. I recall that on the 15th of May, the trial chamber issued a decision on 2 prosecution motions for protective measures for witnesses. The trial chamber granted, inter alia, the prosecution's request for the protective measures of delayed disclosure until 30 days before testimony for witnesses RFJ 079 and RFJ 084. When witnesses RFJ 79 and 84 testify, they will do so in open sessions, as no further protective measures were requested for witnesses 79, and the prosecution's request for rescission of witnesses 84's pseudonym was granted. The trial chamber has been informed that the prosecution may wish to make a further request in relation to protective measures granted to witnesses 79 and 84. Counsel for the prosecution, we can go into private session if you wish to deal with this issue.
I don't believe it's necessary, Mr. President. It was just requesting the chamber to make possibly explicit what we think is already implicit, but just to be sure. In its decision on protective measures, as you've indicated, you've granted a certain status to these witnesses in relation to the disclosure of their identity. And we were just asking if the chamber could make it clear and explicit that the protective measures for these 2 witnesses include that once their identity is disclosed to the defense, that identity and the identifying information that's disclosed with it will not be made available publicly until such time as those witnesses actually testify during the trial proceedings. So we're essentially just asking that the chamber rule that any disclosure to the defense cannot be something that's made public prior to the time that they actually testify.
Thank you. I don't know that I need to hear from defense counsel on this issue. It's been answered. So the trial chamber is satisfied that delaying the disclosure to the public of the identities of the witnesses until they testify will enhance the protective measures in effect for these witnesses and will not impair the right of the accused to a fair trial or the right of the public to access information, as the information will be made public when the witnesses testify. Accordingly, the trial chamber grants the prosecution's request and orders that the identities of witnesses 79 and 84 shall not be disclosed to the public until they appear to testify. Now, I would now invite in turn the prosecution and then in turn counsel for the defense to raise with the chamber any other issues that they would wish to at this stage.
Thank you, Mr. President. Nothing from the prosecution.
Nothing from us. Thank you.
Ni odbrana Simatović nema ništa.
I'm reminded that I should state for the record that the trial chamber accepted the number of witnesses and the time proposed by the prosecution for presenting its case, subject to the trial chamber's subsequent decision on the rules 110, 111, and 112 motions for the admission of evidence. And with that, today's pre-trial conference is at an end, and I thank, as usual, counsel for their usual cooperation in inching this matter forward. Thank you.
All rise. Vaya Bulave.